MOS, Low Yen Ling.
Mr. Speaker, sir, I thank all the 10 honourable members who have spoken in support of the bill for their questions, their comments, and their suggestions. Please allow me to address the points as raised in the course of my speech. As before, for the sake of clarity, I will refer to the Fair Tenancy Industry Committee established under this bill as the FTIC, and for the Fair Tenancy Industry Committee that was formed 2 years ago in May 2021 as current committee in my speech. Mr. Speaker, sir, before I turn to address the members' comments, please allow me very quickly to recap the context for the bill, and I think it has been cited by many honourable members. In June 2020, when we first embarked on the journey to strengthen the retail sector with tenant and landlord representatives from the Pro Tem Committee, to be honest, it was far from certain that any common grounds could be found, let alone a full-fledged and a robust code of conduct that we have before us today in the House for this debate. So the code was, in the words of a current committee member, and I quote her, "a landmark for the industry, and it's a miracle that we could even reach this stage," unquote. This unprecedented bill is also a landmark for the government, like what some members have shared. For the first time, we have tabled a bill that mandates compliance with principles that's drawn from a code that's developed by the industry, that's owned by the industry. And it is because the industry and the stakeholders recognize the need for this code and the benefits, the collective benefits that it can bring to the stakeholders of the retail sector, that we are all here today for the final stage of this bill. As Ms. Jessica Tan pointed out, the code does not set out to, nor does it intend to solve every problem that tenants and the landlord face in their lease negotiation. However, it is a critical first step that brings the industry together at the same table and steer it towards a positive direction for a brighter future. While the COVID-19 pandemic catalyzed the beginnings of the code, as Mr. Murali Pillay, Mr. Satyandi Supat said, the conduct and the spirit of the negotiations, as well as the development of the common leasing principles, will place businesses on a stronger foundation for the long run. And to ensure its continued relevance, the code will be a living document under the current committees and then the FTIC's stewardship, and updated from time to time to meet the industry needs. Since the code was first published in March 2021, it has been updated twice. We are seeing the third version. Mr. Louis Ng asked a question in less than 3 years, 3 versions. Mr. Murali Pillay, Mr. Louis Chua, Mr. Leong Man Wai, Ms. Jin Si in her maiden speech, and many members have given their firm support. And I'm very glad that the bill addresses their concern about the imbalance of bargaining power for small companies in the retail leases. And I fully agree with Mr. Murali Pillay that the bill promotes equality, promotes fairness, and promotes freedom to contract between leasing parties. I also agree with Mr. Don Wee, who have just spoke, that the bill and the code provides small business with guidance and certainty, and thus support entrepreneurship in general, and by helping businesses understand their tenancy rights and making informed leasing decisions, knowing their tenancy rights as well as, on both sides, knowing their obligation. Above all, we are clear that by no means is this bill signalling a shift in the government's position on free market principles, the importance of which Mr. Lim Biao Chuan has stressed in his very passionate speech earlier. Now, on the contrary, the very reason that we are tabling this bill is to promote greater transparency and a more vibrant and competitive retail scene to benefit Singaporeans and all consumers. As highlighted by Mr. Murali Pillay in his passionate speech, the government's underlying philosophy has always been and still is, in the words of then SMS Indrani Raja in 2018, that, I quote her, in general, free market principles should apply and the government should only intervene when necessary, unquote. Intervene when necessary, unquote. The bill supports this approach. It does not seek to intervene in market outcomes and does not seek to inadvertently distort competition or distort market forces at work. Instead, it empowers the industry players in the retail sector to come together to identify, to agree to, and address their key pain points by finding common grounds. The leasing principles under the code are really a result of very extensive deliberation between tenants and landlord representatives. They really represent the fine balance that both sides have struck. The trust and the partnership that tenants and landlord have forged in developing the code together provide a firm foundation for widespread adoption by the industry. And by mandating compliance with the code, the bill will enable both the tenants and the landlords to pursue their business interests more effectively and enhance the competitiveness of our retail scene in Singapore. Mr. Speaker, sir, please allow me to now respond to the members' clarifications on the code and then their clarifications on the bill. I thank all the 10 members for their questions and their suggestions for the code. And to formulate the code, the Pro Tem Committee had spent months deliberating each of the leasing principle extensively. The Pro Tem Committee weighed the views of the tenants, large and small, the landlords, large and small, and incorporated their feedback to come up with a set of common standards that apply to the industry. Careful considerations was also given to ensure that the code is not unduly onerous on any party. The FTIC will certainly continue to drive the review of the code under the bill. Mr. Edward Chia had suggested amending the specific leasing principles to further increase transparency in lease negotiations. Mr. Edward Chia raised a point about electricity costs, I believe, in his speech. He was concerned that while the bill prohibits profiteering from the sale of electricity, tenants are charged for additional miscellaneous costs, such as meter reading fees. Landlords on the ECS scheme, and ECS stands for the En bloc Contestability Scheme, they will have to procure the electricity contracts on behalf of their tenants. And then the landlords are to pass the tenants the electricity costs as charged without any markup. Without any markup. Now, depending on the contract between the electricity retailer and the landlord, the electricity costs may include various components that's charged by the electricity retailer, such as fees for meter leasing and the meter reading. Because the contract between, under the ECS, the contract between, say, electricity retailer with a mall, they will only measure the amount of electricity that the mall use. But then, they will have to provide the individual meter to measure the tenants. So this actually imposed by the electricity retailer. Now, this is so that the sub-meters can be installed for tenants and their electricity consumptions can be tracked. For instance, there are also instances where the landlord are not on ECS. Then those are cases where tenants would be able to choose from the array of electricity retailer of their choice from the open electricity market. So it is thus not practical nor possible for the code to comprehensively come out with different permutation to try to cover the different types of commercial arrangement for electricity. What we want here is to improve transparency and to promote fair practices, to make it clear that the landlord cannot charge markup on electricity costs. Right? So as Ms. Jessica Tan have said, and I quote her, she said this in her speech, we should not expect legislation to be the panacea for all issue, unquote. And what is really important, as cited by many of the speakers today, is that details on costs are communicated transparently during the lease negotiation so that the tenant can make an informed decision whether to lease the premises. Mr. Edward Chia also asked the government if the government or the FTIC could provide guidelines for parties renegotiating the lease agreements due to material adverse change when a tenant cannot carry on its business because of events beyond its control. Parties are encouraged to abide by the principles governing the conduct and the spirit of negotiations as set out in the code, and to negotiate leases in good faith, while also considering the other party's legitimate interests. As circumstances would really differ for each lease, it is thus not feasible to issue guidelines for what would be commercial arrangements between the two parties. Mr. Edward Chia and Mr. Lim Biao Chuan raised some questions about A&P, advertising and promotion, and also service charges during the lease, which landlords are allowed to adjust on the condition that their overall gross rent does not increase. Again, this is to improve transparency and promote fair business practices. So there's certainty, there's predictability for the retail tenants. Now, this condition has been set to prevent landlords from arbitrarily raising the gross rent after the agreement has been signed, and to provide certainty to tenants on the rent that's payable during the lease term. Now, I wish to also clarify that the code does not restrict the amount of the A&P charge that the landlord may collect. Now, as Mr. Lim Biao Chuan noted, the amount of A&P charges that's payable by the tenant is really a matter of negotiation between the parties and continues to do so. Rather, the code holds the position that the A&P charges are considered as business costs incurred by the landlords and should thus be subsumed in the overall gross rent, rather than be borne fully by tenants. In addition, landlords are also encouraged to keep proper records and accounts of these charges to ensure accountability. Because when renewing the lease agreement, tenants and the landlords may review and revise the charges based on prevailing market conditions. Mr. Speaker, sir, Mr. Satyandi Supat and Mr. Louis Chua ask if data transparency guidelines under Part C of the code will be mandated under the bill. I'm happy to confirm this. It will be mandated. The current committee has updated the draft code to raise the bar on data transparency and confidentiality and elevated the status of data transparency and guidelines to be leasing principles. Now, this brings the total number of principles to 13 instead of 11, which the bill mandates compliance with. In cases of non-compliance, parties can pursue recourse in the form of mediation and adjudication. The draft code will be finalized in the coming months and will take effect on the same day as the date of commencement of the Act in early February 2024. Mr. Don Wee and Mr. Louis Chua ask if the data transparency principle in the code can be further strengthened, such as by providing tenants with more information beyond sales data by trade category. Allow me to share that the Pro Tem Committee had considered all these matters in deliberating the data transparency requirement. And the Pro Tem Committee ultimately landed on the position in the code that the members see today to promote greater transparency and enable both tenants and the landlords to make informed lease decisions while balancing both parties' interests. The addition of two leasing principles, confidentiality and data transparency, really demonstrates how the code is a living document, which will continue to evolve to meet the industry needs. While I'm not able to address all the questions that's raised by the members, especially those that are outside the purview of the code and the bill, I will certainly convey your feedback to the current committee for their consideration, including Mr. Lim Biao Chuan's suggestion for reminders to be sent for declaration of the value of CAPEX work. And Mr. Louis Ng asked about the frequency of reviewing the code and its guiding criteria. And then Mr. Satyandi Supat then inquired about rent review and if requiring the minister's approval to amend the code would make it less nimble. I agree with both Mr. Louis Ng and Mr. Satyandi Supat that we will really have to balance between providing flexibility and transparency and giving the business certainty. The current committee considered the industry's feedback when it reviewed the code and will continue to do so. Now, under the bill, MTI will also work with FTIC and ensure that there is sufficient lead time for businesses to familiarize themselves with the latest update on the code and how the updated principles in the code will be implemented before it comes into force. Mr. Speaker, sir, I will now turn to address the members' clarifications on the bill. Mr. Louis Ng asked about the scope of the bill and how might the minister exercise the power to exempt specific persons or premises from the bill. I want to assure him that the government intends for the bill to apply to all retail premises with a lease tenure of 1 year or more. Powers to vary the schedules and to exempt specific entities are not uncommon in other acts, and I would like to assure the member that MTI will exercise such powers under the bill judiciously and only consider doing that in exceptional circumstances. As Mr. Satyandi Supats observed, that some parties may seek to escape compliance with the bill by deliberately structuring their lease in multiple renewal periods of 11 months. Actually, that's quite painful. He's citing that as an example that some, of the tenants or landlord may game it that way. I wish to assure him that the intent really is to cover the vast majority of retail leases and exempt those on short-term lease. But I want to assure him, if any party suspects that their lease terms are being deliberately shortened to circumvent compliance with the code and the bill, they can report to the FTIC such practices for going against the spirit of the code. Mr. Lim Bell Chuan asked about the composition of the FTIC, and he cited that might be a risk of balance or representation tilting towards either side. He noted the importance of this matter as FTIC is responsible for maintaining and proposing changes to the code. I would like to assure him and the House that the Pro-Tem Committee and current committee have done an admirable job balancing the needs of the tenants, large and small, the landlords, large and small, in developing the code so far. And we will continue to work with FTIC to ensure that this momentum continues after the passing of the bill. Mr. Speaker, sir, as I've said at the beginning of the bill, the legislative approach that we have taken for this bill is really a first for the government. We have chosen to do so because, number one, we recognize the potential downsides of over-regulating in the lease negotiation space where market forces and commercial considerations should prevail. And number two, we do so because we recognize that the benefits of having an industry-led body respond very nimbly and that represent the industry aptly to changing needs in the fast-moving retail scene. To ensure accountability in the process and fair consideration of the interests on both sides, the bill requires the FCIC members appointed by the Minister of Trade and Industry to represent the interests of both the tenants and the interests of the landlords, and also require the FTIC to seek the Minister's approval before amending the code. Mr. Edward Shah and Mr. Satyandi Supat asked about the recourse available if landlords do not file declarations of permitted deviation after signing the lease agreement within the period to be prescribed in the regulations. While the bill only requires landlord to file any such declarations with the FTIC, tenants are encouraged to acknowledge these filings. In cases where permitted deviations on exclusivity, number one, number two, sales performance, and number three, security deposit, if this permitted deviation failed to be filed, to answer those questions, the deviation in the lease agreement would be void. And then the default position as stated in the code would then apply. So they have to file it within that period, failing which the deviation on those three areas would be void and the default position in the court would then apply. Then for the fourth scenario, for the fourth leasing principle where deviation is allowed, where it concerns the rental formula, now if the permitted deviation related to rental formula fails to be filed, the lease will continue on the same rental formula. This is really because it is not possible to prescribe a default rental formula in the code or to void the rental formula term in that particular lease agreement as it is an essential element of the contract. On a related note, Mr. Louis Ng asked about the consequences of non-compliance with leasing principles without a permitted deviation. I would like to clarify that that is not permitted. So the reason why we're coming to Parliament today to pass this bill to support this industry-led code is to mandate compliance to the 13 leasing principles. Out of the 13 leasing principles, there are 4 leasing principles where if both parties mutually agree, they can file a declaration of permitted deviation. And I would like to clarify that this is not permitted, okay, because we need mandatory compliance. And in such cases, if he is aware of any, the tenant can decline the lease agreement and in fact report the matter to FTIC. To answer Mr. Satyandi Supat's question on the purpose of requiring parties to file declarations of permitted deviation with the FTIC? This is a good question. Now, these requirements will enable the FTIC to monitor industry trends in relation to the 4 leasing principles of exclusivity, sales performance, security deposit, and rental formula, and then to assess if there's a need to update the code. So I said this is a first step. It's a living document. We will continue to engage the industry to collect feedback, but it has to be done in a way that all parties, come to a consensus at the same table. Now, we keep talking about large tenants, large landlord and small tenants. Actually, landlord can also be small. I will come to that point later. Tenants can also be big. So there are many, many permutations here, and it's important for us to represent the interests of all possible scenarios. Now, I would like to clarify that while deviation represents a departure from the norms that's agreed to at the industry level, the code does provide parties with the flexibility to negotiate the terms that are best suited to the business requirement and the commercial considerations. Now, I want to share that, and I hear from some members, we think that, the reason why there are, permitted deviation in the 4 areas, is it because the landlord weigh in? Actually, interestingly, the tenants are the one who advocate for that flexibility. Because if not, they think that in certain situations, it may be overly restrictive. So I want to address the query by Mr. Leong Man Wai. For example, I understand in our engagements with the stakeholders, and I said there are large and small landlords, there are large and small tenants. I quote you 2 very interesting examples, which didn't come to my mind before my engagement with them. Certain tenants may want to deviate and opt for whichever is higher rental formula, which is currently not permitted in the code, except by mutual agreement. I give you one example. A shop selling ba kwa, they shared that they may have most of their sales around the Lunar New Year period. Of course, maybe you will say, actually we eat ba kwa throughout the whole year. But I think we will agree, you see the long, long queue, 1.5 months before Lunar New Year. So they may actually enjoy a huge spike in their income during that period, rather than a steady income stream year-round compared to other F&B, say like bubble tea shop. So it's just one example. So the ba kwa shop tenant may prefer whichever is higher rental formula, which then will allow them to negotiate with the landlord to pay a lower baseline rent for most of the months, except for during the few months as it tees up to Lunar New Year. And another example is a winter wear shop. I think you do see that in some shopping mall, where the sales during the year-end holiday, or at least for those people who go to Australia during the June holidays, can be a bit higher than other months. So I just want us to think of other possible scenarios. And basically, this is what not just the landlord, it's the tenant reps who told us that they hope for a little bit of flexibility. At least it doesn't encumber them when they go into a lease negotiation for the retail premises. Now, as lease agreement are private contracts between willing parties, tenants and landlord should do their due diligence before signing a lease agreement, which is binding once signed. So parties to the lease agreement are also responsible for ensuring compliance to the code. So tenants and landlord, after signing, I think it is their responsibility to also ensure that there's compliance, failing which they can then proceed to alert FTIC, and then, if need be, there's a dispute resolution body, which I'll touch on later. Now, if the FTIC receives complaint that a party regularly engages in practices or behavior that are against the spirit or against the requirement of the code, it may seek further information from the parties, and it may publicly highlight egregious or non-cooperative behavior and non-compliance behavior. Mr. Muralipillai, Mr. Lim Biao Chuan, and Mr. Satyandi Supat asked about the qualifications of the mediators and also the adjudicators. I want to assure them because most of the 3, out of the 3 speakers, 2 are legally trained. I want to assure them that the panel of mediators and adjudicators appointed by the Authorized Dispute Resolution Body, which will be Singapore Mediation Centre, SMC for short, they will be fully qualified to deal with the matters of non-compliance with the code. The mediators will comprise both legally trained and non-legally trained individuals who must pass SMC's training program with a distinction grade. And all adjudicators have to be legally trained individuals. Now, this is to ensure that they are able to address any legal implications in relation to non-compliance with the code when rendering their decisions. While parties are free to hire their own legal representatives, it is not a requirement. Here, we are trying to make sure if there's a situation of dispute, we are trying to offer a low-cost, expedient kind of avenue. Mr. Murali Pillai, in his speech, also asked about the adjudicator's power to address matters of non-compliance with leasing principles and whether the adjudicator can order both a variation of the lease as well as the compensation to rectify the same matter of non-compliance. This part is going to be quite technical, so you bear with me. Now, I'd like to clarify that the adjudicator can only make a determination to require either a variation of the lease so that it complies with the leasing principle in question. Because that will only come about in the early, as you go through the lease negotiation and as you sign. So this only kicked in during that period, the front part of your lease agreement. So he can either determine a variation of the lease or order a compensation if the leasing principle in question provides for compensation to meet. So I repeat again, the adjudicator can only order compensation if the leasing principle in question provides for compensation to meet. And currently, if you look at the FTIC code, which is available, check out the URL www.ftic.org.sg, 39 pages all there. Currently, compensation explicitly applies to 3 leasing principles in the code relating to early termination of contracts. So in other cases of non-compliance where the leasing principle does not provide for recourse of compensation, the aggrieved party may wish to seek damages through independent civil redress, like what he cited. Mr. Murali Pillai and Mr. Satyandi Supat asked if the dispute resolution process under the bill supersedes the court proceedings. It does not. I want to assure them it does not. While we encourage parties to use the mediation and the adjudication services that set out in the bill for court-related complaints, this dispute resolution framework is provided in addition to any other redress that the parties would have outside the bill. As I've said, we want to do this because we want to provide the aggrieved party a low-cost and expedient avenue. Now, it is not intended to override any other such redress. The court would certainly have the discretion whether to hear or to determine the matter or to grant a stay of proceedings after considering all relevant circumstances. Mr. Murali Pillai's last question concerns the scope to appeal the decisions of the adjudicator. As I've shared, the dispute resolution framework under the bill is intended to be low cost and expedient alternative to other forms of redress available to the parties. So it does not supplant the court's jurisdiction. Parties can only seek mediation or adjudication in relation to non-compliance with the leasing principles, which have been clearly set out in the code. Thus, most cases before the adjudicator should be able to be determined in a relatively straightforward manner. Sir, before I conclude, please allow me to say a few words in Mandarin. 议长先生，在2021年3月发表的本地零售场所租约行为守则，由业界主导，推动了租户和业主之间更加公平、更加平衡的协商方式，帮助解决了一些结构性的问题，也让租户和业主之间建立起互惠互利的伙伴关系。而这项零售场所租赁协议法案将立法确保所有的租户和业主都遵守这一套守则。通过这项法案，我们希望进一步的鼓励本地的创业生态，帮助有意创业者了解租户的权益，做出更加明智的商业决定，也同时为本地零售业奠定坚实的基础，打造一个更有活力、更有竞争力的零售环境，为顾客带来更好的消费体验。业者凯德置地，英文名叫做 CapitaLand， 和我们分享，他们在采纳行为手册后，加强了和租户之间的关系，双方携手合作，共同的加强商场的活力，为顾客呈现更加精彩的购物体验。黄文宏议员和蔡秦伟议员呢，他们两位问到，如何能够让中小型企业更加的了解法案和行为守则，以及相关的合规费用？安迪议员和林谋权议员也对较小型的业者是否已经做好合规的准备表示非常关注。我们了解大家的关注和意见，因此我们花了2年的时间，我们开始就确保把这套守则简单明了，确保它是简单明了，确保它是容易遵守。此外，政府也将和公平租约委员会、全国商联总会以及新加坡邻里企业中心紧密的合作，举办多个说明会。尤其从现在到明年2月，我们会逐步在各个选区主办很多这个说明会，而且在这个邻里中心呢，我可以向黄文宏议员保证哦，不单单是用英语来进行，我们打算用华语。不过他刚才难倒我了，还问我有没有用方言来进行，这个我要跟全国商联总会磋商一下哦。所以我们政府将会和公平租约委员会、全国商联总会以及新加坡邻里企业中心紧密的合作，主办多个说明会，向我们的邻里商家说明法案和守则的细节。商家们也可以向新加坡邻里企业中心的商业顾问了解法案和守则的详情。全国商联总会呢，也将根据邻里商家的租赁需求，特别的制定适合邻里企业使用的租约样本，并在今年的这个年底呢推出。所以我们十分感谢商会商团，包括全国商联总会，还有呢新加坡餐饮业协会 （Restaurant Association of Singapore） 自动自发的推出适合各自行业的样本、清单和资源，让商家带来更多的便利。公平租约委员会呢，也将会继续聆听业界的反馈，适当的更新零售业场所租约行为守则。举一个例子，这个例子很重要。有一个例子哦，就是我们在进行这些路演的时候，这2年在进行路演，我们就去到这个全国商联总会、新加坡邻里企业中心，那很多邻里商家们就聊了，跟他们讲一下这个法案，他们就提出了一个反馈。他们向委员会提出的反馈呢，是为新租约提供这个测量师认证的平面图，其实会为这些小零售业我们的这个商店们增加这个租赁的成本。那我们听了这个反馈呢，那这个公平租约委员会检讨过后呢，认为只要业主和租户呢2个他们都彼此同意，只需要递交政府部门认证的平面图或者是建筑图就可以了。这个是很重要的一个例子哦，代表了其实这个委员会是细心的聆听这个零售业者，不单是大小的这个商店，还有这个当然这个业主等等。所以这个做法呢，其实能帮助到业主更方便，而且又省钱。这份修订后的行为守则呢，预计将在明年2月初和法案同时生效。Mr. Speaker, sir, I believe that I've addressed the key issues that's raised by the members. And as we can see from the last 2.5 hours of debate, the passionate speeches by the 10 members, we have heard different voices in the chamber today. On one hand, some members think that the code can go further to address imbalances in the lease negotiations, while others worry that it may go too far. And some see the bill as an exemplary example of our collaborative approach, uniquely Singapore, to problem solving, while some caution that not all issues require government to step in, and not all issues require government's intervention. So as you can see, as you can hear from the 10 speeches from the members, the diversity of views held amongst the 10 speakers, I was reflecting, it truly reflects the extensive and spirited discussions that have taken place these 2 years in the industry between the landlords, tenants, large and small, landlord, large and small tenants. So, Mr. Speaker, sir, the code embodies the common ground that's found by the tenants and the landlord to breach these differences. And it has been welcomed as a groundbreaking achievement for the industry, developed by the industry, owned by the industry. I'm very heartened that all 10 members affirm the importance of the code and the need for the bill to ensure widespread adoption. To conclude, I would like to reiterate that the code is a living document and will continue to evolve to meet the needs of the industry. This will allow new and current players to navigate the market more adroitly and adapt to disruptions with greater resilience. I'm confident that by ensuring fair and balanced lease negotiations, the bill will strengthen the foundations of the retail market. The FTIC will also be a positive driving force in fine-tuning the code and bring stakeholders together to push the industry to greater heights. I would like to thank all the members, the 10 members, for their support of the bill, and I trust that with the support of the House today and the retail industry for this bill and the code, we will place the retail sector on solid ground for future growth and greater potential. Sir, I beg to move.
Are there any clarifications for MOS law? I don't see any. The question is that the bill be now read a second time. As many as are of the opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it.
Lease Agreements for Retail Premises Bill.
Committee stage what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 35 stand part of the bill. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that the first and second schedules stand part of the bill. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. Bill to be reported. MOS, Low Yen Ling.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it.
Lease Agreements for Retail Premises Bill.
Before I call the Deputy Leader, next Wednesday we celebrate our country's 58th birthday. So let me wish everyone a happy National Day in advance. Deputy Leader.
Mr. Speaker, on behalf of Leader, I beg to move that it is rising today, Parliament would stand adjourned to a date to be fixed.
The question is that at its rising today, Parliament do stand adjourned to a date to be fixed. As many as are of their opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it.
Speaker, I beg to move that Parliament do now adjourn.
The question is that Parliament do now adjourn.